Hello, everyone. Welcome to our webinar today. Our topic of the day is, does COVID-19 impact the enforcement of commercial contracts and real property leases? We are so glad that you're able to join us. With us, we have attorney Rich Abdallah. Mr. Abdallah has over 35 years of experience in the areas of employment, real estate, and business law, including transactions, litigation, and he has written numerous articles giving seminars to attorneys and organizations on a variety of legal subjects. We are very fortunate to have him here with us today. Before we get started, I would like to remind everyone, if you have any questions for Rich, please write them down on the tab and he will get to you as soon as possible once the presentation is over. Meanwhile, let's go over to Rich and get started for this today. Rich, it's all yours.
Do you want me to begin now, or are we going to wait?
Yes, please. Go ahead.
Okay. Good morning, everyone, and welcome to the presentation that I have put together for the chamber members in particular. Obviously, we are in a situation that the vast majority of us have never encountered. And we also don't know when it's going to end. So we are in a very fluid flux period in terms of the pandemic, and also in terms of the impact it might have on our businesses or our leases. So I'm trying to give you some guidelines today that may help you in deciding, what to do. Most businesses have been closed for at least 3 months. Some of them have just cannot do business and have closed their doors. Question is, do they still have liability on their lease, for example? Well, let's start with the first slide, because I think this will help us move through the material. Does the stay-at-home order by itself allow either party to a contract to unilaterally terminate the agreement? Governor Newsom's stay-at-home order has created challenges for both businesses and real property contracts. Now, whether or not a party to a contract can legally terminate the agreement depends on the terms of the agreement. And we're going to start with commercial contracts. Next slide, please. I still have commercial contract. Oh, here we go. Does a force majeure, I believe that's the correct way of pronouncing it, provision in a contract and real property lease excuse or delay the party's obligation due to the delay or unforeseen circumstance? Okay. Most of us as attorneys haven't really encountered this particular term in terms of what it means, force majeure. I hope that's the correct way to pronounce it. But it is a common provision that appears in contracts and real property leases. The concept is that in the event of an unforeseen situation or circumstance, such as a riot, hurricane, pandemic, or other across the board or massive event that impairs the one or both parties' ability to perform either the contract or on the lease, does that constitute grounds for termination, unilateral termination of the agreement or of the lease? If it does, then it may be that the parties, one or the other party, has the right to terminate the agreement. I'm initially going to talk about just contracts rather than leases. That'll be in the second section. The first thing that I want you to be aware of is this does appear in a lot of agreements as force majeure provision. However, the courts have generally narrowly construed the terms of such a provision, and they're all different. Surprisingly, they are all a little bit different. Some of them have specified events that constitute force majeure or come within the force majeure provision. Some use certain events as examples and then say something like this, but not excluding other similar events or natural tragedies, or in this case, national tragedies, perhaps worldwide tragedies. All right, so the courts are going to look at these provisions, and there isn't a one-size-fits-all in terms of looking at whether or not the agreement or the force majeure applies in a particular circumstance. When it comes to a lease, by the way, and this is the most commonly perhaps misunderstood provision, and I've seen this come up. I've represented both landlords and tenants. Even if the force majeure provision specifically applies to the circumstances occurring outside of the contract, in this case the pandemic, it doesn't eliminate the obligation to pay rent. That's a very common provision. Nor does it eliminate the landlord's responsibility or obligation to make payments on or credits towards the lease itself. So that's probably the one most common problem that you encounter as a party to a contract, is that if you're a tenant, you're still not out of the obligation of paying the rent. Okay, let's try the next slide. To invoke the rights under this force majeure provision, the contract, first of all, has to contain the provision. And as I said a little bit earlier, the provision must specify the event that the party is using as the basis to seek termination or delay. And as I said before, you have to take a look at that provision in the contract and determine whether or not it squarely fits within the situation that you're facing. And if it does not, then you've got a new problem to deal with. In some cases, the provision will allow the party the right it wishes to exercise, for example, delay construction for the duration of a hurricane. And that's probably a really good example of what we'll talk about a little bit later. Sometimes the force or the pandemic or other force majeure event provides an excuse for one party to a contract to not perform for some period of time temporarily. I mean, a hurricane would be a good example. A hurricane comes in, obviously more common in the South or in the Midwest, and it's flooded, and you just can't work. You can't operate equipment. And it takes a month, 2 months, 3 months before the conditions are adequately cleaned up or improved so that you can continue on the contract. Well, the problem is if that situation continues for 2 months, 1 month or 2 months, that might be a temporary situation. But as I'll talk about a little bit further, and the pandemic that we're particularly concerned with here is running into that question about whether it's a temporary delay or is this going to be permanent. And we'll discuss that a little bit further. Okay, Anjali, could you go to the next slide for me, please? Suppose your contract doesn't contain a force majeure clause. The question is, are there other legal grounds to delay performance or terminate a commercial contract? There are a couple of other provisions. Impossibility is one. And these are terms that have been interpreted by the courts, and each state has a slightly different interpretation. Impossibility refers to the party's inability to perform under the contract because doing so is impossible. A hurricane comes in, there's a flood, I can't get to the structure or the building or the road or whatever we have contracted to build because there's 4 feet of water and you can't do the work in 4 feet of water. The second criteria, if you will, for enacting or raising the issue of impossibility as a defense to performance on a contract is that the party's inability to perform is the reason it's not performing at this particular moment. It doesn't address or doesn't give the person an out because the obligation can't be performed because the party has another problem. We'll talk about that in just a minute. So for example, if you contract to do certain work, let's say construction, for example, and for some reason or another, the cost of the materials, be it construction materials or otherwise, skyrockets for one reason or another, and the source of the materials that you had planned on using now wants to charge 400% of the amount that they were charging at the time you entered in the contract. Does that constitute an impossibility to perform the contract? It probably doesn't. It probably doesn't. But if you can't go to the site because there's been a hurricane and there's a flood, it's impossible for you to do that work, whether you have the construction materials or not. Okay. All right, the next slide, please. Frustration of purpose. Frustration of purpose refers to an unforeseen circumstance that substantially destroys the value of the performance to one of the parties. The frustration must be severe and not reasonably foreseeable. Okay. Furthermore, the mere financial loss or lack of profitability as a result of the events may not be sufficient. So frustration of purpose kind of carries over or ties in with impossibility. I gave you the example of the contractor who enters into a contract believing that his materials are going to cost him $100,000, and that's built into the bid. For one reason or another, the materials that he plans to incorporate into the construction project skyrocket in cost for one reason or another. Maybe a flood in another country where the supplier is primarily located. Sometimes there is a sole source for a particular material. And all of a sudden, for whatever reason, the supplier decides I can charge 300 or 400%, for that product. I'm gonna give you an example. Do you remember we all were looking for masks? When the pandemic was causing a great deal of panic, frankly, panic buying, people were selling the paper masks, for $30 a mask. I can get 10 now for $10, at certain locations. While that is not a great example, it does indicate a situation in which the supply is limited, not because there's a problem in another country, but because the nature of the quantity that was normally produced is unable to rise to the level of producing product to meet the demand. Most of you have, I'm sure, taken your economics class in high school, college. Supply and demand. Suddenly masks are in much greater demand than the supply. So some stores were charging exorbitant fees for that. Well, let's suppose you take that situation and it occurs with regard to supplies that a builder or contractor was planning to use. And there's nothing wrong with the manufacturing. It's just there's a run, let's say, on this product. I mean, and all of a sudden, the price goes way up. Is that frustration? Of course it is. But is it sufficient to terminate the contract for the contractor in that particular case? Probably not. But again, these are taken on a case-by-case basis. What happens, though, if your contractor says, well, I had planned on $10 a square foot for this material, and that's the bid. That's the basis of the bid I gave, and that material represents 90% of the construction cost. And now there's a shortage of it when I'm starting, and now it's $100 a square foot. Is that, a frustration of purpose? Possibly. if the contractor is going to end up paying so much for the material that there's not just a loss, it just doesn't make any sense. There may be a practical reason at that point to not do the contract. It may be better to take your chances with the contractor in court. So frustration of purpose and impossibility are both defenses that can be raised in connection with contracts, whether there's a force majeure provision or not. So these are three areas that you might take a look at. Okay, next slide, please. I have one that shows, why don't you go back one? I'm sorry, go back up. Okay, one more. Okay, I gave, this is a little out of order, but these are fact situations that I found in cases that might be of help to you. By the way, a lot of these cases tend to arise around World War II, and you'll kind of see why that is. But these examples of situations that do not meet the requirements to take advantage of the force majeure provision, do not meet the inability to obtain necessary tools because the supplier is on strike. Contractor says, I can't get this particular device or package of materials or tools that I need unique to this project because the supplier is on strike and we can't get anything. That's not probably going to meet the force majeure provision. Mere economic downturn in the market for a product. You're planning to buy 1,000 widgets at $10 a widget and then resell them after you do some kind of a special treatment to the widget to the public at $30 a widget. But it turns out that the demand for that product, because of certain economic conditions, can't sustain a price of $30, and it's back down to $10 or $15, and you're not going to make any profit. That's not enough to take advantage of the force majeure provision. Changes in the market price, we've talked about that a little bit. That's not going to be enough. All of these things were construed by the court as being factors that the contractor could have taken into consideration or should have taken into consideration. Finally, the greater expense or hardship than anticipated. Gee, I thought I was going to be able to get these shipped over from country X and pick up at the dock. Well, the shipping companies are now on strike, and for me to get that, I have to literally go over and get the product. So those are examples of which the court said, no, that's not enough to constitute the defense of force majeure. Okay. Possibility, frustration of purpose. Next one. Commercial property leases. These are a little different, and frankly, every contract is different. You would be not doing yourself a you would be doing yourself a disservice if you leave here and say, well, Rich said this at the meeting. I took photo shots, and I'm going to take a look at my contract. I can tell you from experience that all these contracts are different, and the force majeure provisions are different. The most common situation that we're encountering now is commercial leases. To analyze whether or not you have the ability to get out, if you will, or unilaterally terminate the lease, the first thing you have to look at is what are the permitted leases, lease uses. Let me give you two extreme examples that I've actually encountered in my practice. One lease was for an office building. For one reason or another, the lease, which I didn't review or approve, did not have any purpose written into it. So the court would likely construe that as, hey, you can use it for any legal purpose. Obviously, you can't turn it into an illegal operation, but you could use it for any legal purpose. The fact that the pandemic has made it less desirable for you to use it as an office, that's not an excuse, because the deed does not restrict you to a particular use. Okay. At the other end of the spectrum, the lease contract says, why don't you go up a little bit, because I think it's on the next slide. Okay. The The other situation, and these are in reverse order, is where the lease specifically says the property can be used only for a particular purpose. These are very common in strip mall leases. I've had situations where my client does a particular Southern barbecue, and they're angry because the landlord that operates the strip mall allowed restaurant X down the road in the same mall to sell barbecue. And the argument is, hey, I was supposed to have exclusive opportunity to sell barbecue. That's the tenant side. The landlord side would be, look, you're going to, as I give in my example here, operate, a vegan food restaurant and for no other purpose. Now, why would he do that? Well, you want to restrict the tenant. As a landlord, I want to restrict the tenant to only doing one food. So if you move in and you open a vegan restaurant and it fails or eventually fails, you can't reopen it as another type of restaurant, maybe an ethnic restaurant, because I want to, as the landlord, I want to protect the value of the other tenants' leases. So if somebody is already operating, let's say a barbecue, specialty restaurant in the mall, and you have a you have a lease that will allow you to operate a vegan store or vegan restaurant, it fails. And they say, well, we can't operate. It's impossible. Nobody's eating vegan food for one reason or another. We don't know why, or it's fallen under, it's much less popular. We want to now operate, we'd like to do a barbecue restaurant because these guys down here have a long line in front of their restaurant all the time. Well, I, as the landlord, want to protect my tenants from competition, direct competition. And if I let the vegan restaurant go ahead and operate a barbecue, then I've got two tenants who are operating a barbecue restaurant now competing against one another and likely drawing profits from the more successful barbecue restaurant to the other newer barbecue restaurant that was once a vegan restaurant. So I had a client call me up the other day and said, we have a strip mall and this particular tenant is limited to, the contract says she can only do childcare services. And you can well imagine that parents aren't allowing their kids to go to these childcare facilities where the kids are all interacting and touching one another. And imagine trying to tell 3-year-olds to stay 6 feet away from one another. That's not going to happen. And it's contradictory to one of the things that you want the kids to do, and that is have social interaction. So the tenant was saying, I think I'm going to have to terminate the lease or get a lower lease rate until we see where this goes. I told the landlord she has a lease that says she can only operate a child care center. And no one can argue today that these child care centers are probably going out of business, and through no fault of their own, only because of the stay-at-home restrictions and the closing of these facilities. If you're on that list of facilities that are closed, restaurant operations that are closed, or businesses that are closed, you got a pretty good argument, I can't operate at all. So I told the landlord that under the circumstances, she may very well be able to terminate the lease without penalty or without loss of, without a cost. The landlord was not happy with me. And the landlord said, well, you mean she can just do that without, essentially consulting us? Or I said, well, you wrote the lease. And the lease says she can only operate a child care facility. So now you're telling me that because she can only operate a child care facility and they're losing money and they can't operate at all with the governor's stay at home and the closures that are being announced, that she doesn't have the right to terminate the lease. He was not happy with me, and I haven't heard from him since. But that's the bad news when you restrict the tenant to a particular use of the property. Restaurants are probably a pretty good one because that comes up a lot in strip malls. You're familiar, I'm sure, with the food court over at Valley Fair. Imagine, I mean, there are a lot of food offerings there that are awfully close, but um, if you had three restaurants with all with the same ethnic or other focused type of food, and they decided to all do something exactly the same, that would be a real problem for the landlord. So the landlord's trying to protect its tenants to the best of its ability from direct competition from others. Okay. All right, let's try the next slide. Back up a little bit there. Okay. It's not sufficient that the purpose of one party of the contract is frustrated. For example, let's suppose that the tenant intended to use and operate the premises as a beauty salon, which is now closed by executive order. But the lease allows any legally permitted use. In other words, the lease says you may use this property for any permitted use. What I mean by permitted is some uses are automatic. You don't have to get a use permit. Some require a conditional use permit. Restaurants almost always require a conditional use permit for a lot of reasons, by the way. But let's suppose it's a freestanding building and the landlord says, hey, as long as you're paying your rent and the operation is legal, I don't really care what you do in it. So the tenant starts out and says, well, this is where I'm going to build my beauty salon. They build a beauty salon. They put in tens of thousands of dollars of improvements. 10 days later, the order comes out to shut down all beauty salons because of the COVID-19 pandemic. Will that mean the tenant can say, well, my anticipation, my desire for this lease was to do a beauty salon. They're closed. I can't do it anymore. I'm closed. I'm out of business. I want to terminate my lease. Well, the landlord's in a position in that situation to say, but the lease says you can operate any business you wish. So you can do one of two things. You can either change your business or you can consider subleasing the property. If the tenant were to come back and say, but I'm a licensed beautician or whatever it takes to do this, I can't do anything else besides operate a beauty salon, that isn't going to be enough when the lease says the use of the property is for any permitted use, any legally permitted use, and does not restrict the tenant to a particular use. I would say more often than not, the lease contains a specific use, but not always. And I mentioned I just saw one last week where there was no use specified in the lease. So I think the court would interpret that as allowing the tenant to use the property for any legal use. Okay, next slide. What if the government restriction makes the lease less profitable or entirely unprofitable? The general rule is that the loss of profitability due to government restrictions does not form the basis for the termination of a lease. Example, I sell a particular product or group of products, and suddenly the cost of those products has gone through the roof. For example, President Trump just did an advertisement, which I have never seen in my lifetime done by a president, promoting that Goya brand Mexican food, which is apparently a popular ethnic food anyway. Suppose that that advertisement, and if you will, blessing by the president, creates an unnatural or exorbitant demand for the product. And the supplier says, well, gee, I can only supply you X number of units. The retailer is going to say, well, I can now get 4 or 5 times that amount for those units until you're able to produce enough to meet the demand. And I am a Mexican restaurant operator, and I go to the store to pick up my products. I use Goya because I think it's out there, it's good, it's reliable, or whatever. And now suddenly the product, instead of costing me $20 a can is now costing me $100 a can. And I can't make any money on my business because the cost of my products is a huge portion or a very large portion of my cost of doing business. Can I go to the landlord and say, look, I can't make a profit anymore. In fact, I'm going to lose money because the supplier has decided and can and kind of enforce this, that the price of a major product that we use in our products, group of products that we use in our business can command a much higher price. And I can't even raise the price enough to make even a slim margin. So I just want to walk away because, it's just not profitable for me to do this anymore. What if the government restriction is what makes the activity or the product not so profitable? Again, that's not enough. The restriction must render the lease either meaningless or destroy its value. I don't have an example for this. We haven't faced that yet. That may very well be a defense to some of these businesses that operate, while COVID is going on. So profitability, if the general loss of profitability would be enough to get out of a lease, anyone can get out of a lease. But if the profitability loss is due to a government restriction, that may not be enough to form the basis for termination of lease. The most obvious one is what we're faced now with the minimizing the restaurant use. You can only do pickup and takeout. Okay, you can't serve inside, but you can do pickup and takeout. Well, as it turns out, very few restaurants can make the level of sales that they were doing before when they had a full service restaurant and they were serving people inside. That certainly reduces the profitability. And is that grounds for the restaurant to get out of the lease? Probably not. Probably not. There may be a caveat to this that, well, what if this goes on now for a year? Has that restriction become permanent, which we'll talk about in a minute. Anjali, let's go to the next slide. All right. Yeah, this is a good example. As I said before, a number of these cases come out of World War II. And I see I have a misspelling there, but in this case, and this went through the court system, the tenant leases an electric advertising sign, intended for use at night. The government issues an order prohibiting the illumination of all outside neon signs at night. Misspelled. The date was 1944 when the U.S. was involved in World War II. The landlord took the position that, well, no, he can use the sign during the day. And the lessee took the position that, no, I only bought that because a neon or lighted sign is effective at night. And in this particular case, based on the evidence, the court concluded that the purpose of the lease was to advertise at night, not during the day, so the lease could be terminated. That's a pretty unique fact situation, but that's the idea. If you can show that it was intended that I do a particular operation with a product or a piece of equipment, and I can only do it at certain times, and that's now prohibited, you may be able to terminate the lease. All right. Next slide. Now, is the lease stayed or terminated during these periods of restriction? A temporary period where the lease terms cannot be fulfilled does not justify temporary terminating the agreement, unless time is of the essence, provision typically found in real estate contracts, or the temporary impossibility defeats the purpose of the agreement. Well, again, you're going to have to look at each contract, and you're going to have to look at, well, it was agreed that every month I would supply you with this product because you need it on a monthly basis, and I can only get it on a monthly basis. I can get enough supply to sell to you on a monthly basis. The contract requires me to provide the product to you on a monthly basis, and I can't get it anymore. The government's prohibited the sale of that product. It's impossible for me to now perform under the contract because I can't get the product anywhere else. It was under the terms of the contract. I had to supply you with a particular brand, a particular type, so I can only get it from one source. While they haven't raised the price for one reason or another, strike, for example, or a flood or other catastrophe, the manufacturer, and there's only one, isn't selling any more of that because of this particular delay or the particular problem they're encountering. So as the next paragraph indicates, the obligations under a lease may be suspended during the period unless the performance after the restriction is lifted would impose a substantially greater burden than terminating the contract, or, and this is where it becomes very relevant, the temporary impossibility becomes permanent. Now, no one knows how long this present COVID stay-at-home restrictions will last. No one knows how long the closing provisions will last. At some point, 6 months, 9 months, it's hard to tell at this point in time what that might be. The so-called temporary restrictions that the governor has enacted on restaurants and other businesses may become virtually permanent. Whether that's 6 months, as I say, or 9 months or a year, I can't tell you today because there's no definition. That's why you have to decide if there's any way you can conduct your business partly or on an abbreviated basis or on a lower volume basis during this period of time. That's probably the best thing to do. But at some point you may say, well, I'm losing 50% of my profit. I can't go more than 6 months without going into the red significantly. And after that, even if I continued at a part-time or part service level, I'll still be losing money. And it's just crazy for me to continue to work that way. Some businesses will be absolutely shut out. Any business that involves children probably will be out of business immediately. Do they have a right to terminate a lease? It depends. You need to take a look at the lease. Probably, because you can't function, you can't provide services on the internet or on a Zoom as we are today, or the like. So it's very possible that they may be out of business. The problem arises when the governor says the restriction will be 90 days. And the company or vendor or retailer says, well, I think I can make it through 90 days, but I have to open up 100% after that 90 days. So I will still be paying the lease because I think he said it was going to be 90 days. I think I can make that, especially with these PPP loans and other financial assistance. And 90 days goes by, you get geared up, ramped up to start your business in full swing, and you think it will come back close to 100%. The day before the 90 days goes up, the governor extends the closure, which is exactly what's happened. And now I'm at a point where, okay, I can't go more than 90 days with no business and even have a chance of breaking even if I go operate at full capacity till the end of the year. At that point, you really have to make a hard decision. Again, take a look at the agreement. Okay, so whether a temporary restriction becomes permanent depends on the circumstances. And it will be something that will be very highly litigated over some period of time because the governor has extended periods of time that were promised to be shorter before. He may extend these for a full year. I don't know. None of us know. So, all right, I'm pretty much wrapping it up. So I want you to come away with 2 or 3 bullet points. Every agreement is different in one way or another. What I say about a contract today, you really can't just take that and say, well, Rich said that force majeure, I'm going to read it. It's not worth taking a chance. Hire a professional who has knowledge of these things. Obviously, lawyers should do that, who do real estate and business litigation, and get an hour consultation or 2 hour consultation. It'll be worth it to you. And there's an X factor in all this. What I tell you today about, for example, a temporary restriction versus a permanent restriction, I may have to adjust tomorrow if the governor continues to tell us, well, it'll be 6 months or 3 months. And then at the end of that period, he suddenly decides, well, I need to extend this. And by the way, it would be kind of, I think, foolish not to expect the current level of closures, especially for restaurants and other businesses where there are gatherings, especially for schools, that this pandemic is going to be resolved in the next 3 to 6 months. That doesn't look like it's going to happen. So you got to think about that a little bit. Is it going to be worth it to me to take my chances? I think landlords are going to wake up that they have to cut their losses. If you run a case through the court system right now, it could, and let's say the tenant has abandoned the premises and given you the use of those premises back to the landlord. The landlord then has a responsibility for trying to release that property. You can't just sit back and say, well, we'll wait and see. Maybe I will, maybe I won't. What do you think the chances are that the landlord is going to be able to release that property in the near future? Probably not very good. So there's a lot of things that are going to go on here that are going to have to be sorted out at a later time. The other thing we don't know, too, is the other X factor is, will the legislature or the governor enact statutes to address the problems or some of the problems that I've just discussed? For example, they'll be hearing a lot from consumers and from landlords and from commercial tenants about, yeah, what about this and what about that? And I think they're going to see that this could result in a major flood to the court system for resolution. A court resolution is not a good idea. It's costly, time consuming, and nobody ever really gets what they were hoping for. I can tell you this is my 43rd year of practice, that I was told early on that 95% of the cases settle, and that's true. Very few of my cases ever go to trial. What does that mean, though? That means that usually the attorney's fees that are incurred by the landlord and the tenant or the contracting parties are usually the responsibility of that party. In other words, the landlord takes care of its own fees and the tenant takes care of its fees. And guess what? Then you start looking at, well, we agreed to settle it for $50,000, but I had to pay my lawyer $30,000. Now I really only netted 20, and it took me a year and a half to get there, and a lot of consternation and a lot of exasperation, if you will. So there are a couple things that could happen. One, the closures could be continued, and the legislature or the governor may enact statutes that try to address the various situations that I've talked about, because there's going to be major litigation over this over the next few years. Get an hour or two with an attorney, have them take a look at your lease, and you need to tell them what the nature of the business is. And he or she could probably give you a best guess as to what these court systems will do. Will the judges be sympathetic to persons who are trying to get out of a document or get out of a lease? Or will they be more conservative and say, well, the tenant didn't do enough before walking away from the lease, and therefore they didn't have the right to unilaterally terminate it? So I hope I've just given you enough to say, this is kind of an area that I need to get some feedback from, because I can't stress enough that this is hard enough for lawyers to do. And we don't exactly have rote answers for you in these areas. So I hope I've given you enough information to help you think about your particular situation, and maybe have it take a look now before it gets too late, so to speak.
So we do have a few questions, Rich, that I
Okay.
will read to you.
All right.
I think the first one has been answered. It was Gordon was asking, in these difficult times, can we terminate the commercial lease? And I think you kind of went through it.
Depends.
And it depends.
As usual, it depends on the lease, and it depends on the nature of the business, and it depends on a number of factors.
Right. Going on to Phil's question, if we are not an essential business, can we terminate an office lease?
Um, Again, if the lease says you can use the leased premises for any legal use, then you probably have a problem. If the lease says you can only use it for a particular kind of business, and the statutes or the regulations prohibit you from operating that business in that locale, you might have the ability to get out of it. But again, that one's real close. So you really need to take a really good look at that before you just don't abandon without getting some help.
The next question is from Vijay. He says, what are the rent relief happenings in the market currently? How much concessions are the landlords offering? I was told some places there's 3 to 6 month rent free, other places 50% until situation improves.
Mm-hmm.
Just wanted to see if you have any ideas what the landlords are considering.
Yeah. I think initially landlords were pretty rigid about coming to a conclusion, trying to reach an agreement before going to court. If I represent a landlord, I think it's incumbent upon me to say, if they vacate the premises, then you have the obligation to hire a leasing agent and to find a tenant. You can't just sit back, file a lawsuit, and wait and see. And I tell my tenant clients, if you have to leave and you have a good excuse, the landlord really has the burden now of trying to find a new tenant. They may not. I mean, given the circumstances, they may not be able to do that. But I think it depends a little on who the landlord is, whether or not you're dealing with a local owner versus a major corporation. A lot of times I find with the corporations, they want uniformity. No matter whether the corporation is headquartered in New Jersey, they don't care. I mean, this is what they want to do across the board. So I think as we go along, landlords are going to become more and more realistic that, a bird in the hand is worth two in the bush. And as I said before, I always tell my clients, be very careful because the attorney's fees run up really fast and cases almost always settle. And with that in mind, my admonition at the beginning of a lawsuit is be careful. I don't want you upset that, hey, it cost me this amount in attorney's fees, but I only won this. I really only netted a third of what I hoped I should get. That often happens. That very often happens. And maybe that's the difference between having gone through the wars on these things that I can say, I know this is what happens because I've experienced it. So I think the answer to your question is, I think landlords are becoming more and more aware, landlords in particular. And of course, we're talking about commercial leases. I'm not talking about residential. It's a whole different situation. But I think they're beginning to realize when the lawyers say, they're going to abandon the property. You're going to have to file a lawsuit, not for unlawful detainer, for breach of agreement. All of my lawsuits that are in the pipeline at the court have been pushed back 6 months to a year. So you can only imagine you might not get to court for a year or a year and a half on your case. Well, what happens in the meantime? So I know that's somewhat of a vague answer, but I think that's what I'm advising landlords. You still have the obligation to try to relet. You may not see any money for a year or two. You're going to have my fees. Be careful. It's not a good investment of your money. And getting something now, you can still rent it out. And usually the agreements say, even if I rent it out tomorrow, the money I get from you, tenant, was not an offset to what you own. I hope that helps.
So a follow-up question Vijay has was, we have a cookie shop in the mall and within 100 meters, they permitted a competitor which poses a direct competition. The landlord does not consider it as a competition.
Well, that's a wholly different question. What I would recommend there is that you have to take a look at the lease. Usually landlords do exactly what you've described. They say only you can only sell cookies. And they don't promise that we won't let somebody else sell cookies. So in that situation, chances are the lease will say, tenant sell cookies and only cookies. And they will not have a provision that says, and we won't have anyone else sell cookies, because there's a reason for that. Sometimes they will bring in a tenant for another unit that does sell some cookies, but it's only a sideline or something like that. So you have to take a look at the lease. Unless the lease promises the tenant that no other type of competing business will be allowed, then you probably have a problem. You're probably stuck.
We have a question from Victoria. She's asking, so can a tenant get out of the lease if it's a strict use lease? What about personal guarantee?
If it's a what lease?
A strict, like, they've identified.
Oh, a strict use lease. Yes. I mean, I had that just the other day. I mean,
a personal guarantee.
Yeah, the guarantors, first of all, take a look at the guarantor's provision. I had a matter come in the other day, and the guarantee was completely unenforceable. I mean, it had nothing in it that was required. A guarantee should be actually a separate document with all of the covenants written into it. Having somebody sign a lease and say, oh, I'm going to guarantee this lease with nothing explaining what the guarantee is not going to be enforceable. If the tenant has legal grounds to terminate the lease, then the guarantor is off the hook too. If the tenant has legal grounds to terminate the lease. If the tenant leaves without legal grounds, then the landlord will pursue the tenant and the guarantor. And the argument will be, they shouldn't have left, they owe me money, they can't pay, you have to pay me as the guarantor.
Another attendee is asking, what is your experience convincing landlords to adjust the lease in this current situation to allow uses they had not agreed on in the original lease?
It depends on the nature of the practice and what is going on in that building. My landlord clients, I'm trying to bring them home to a reality of, if they leave, there's not much you can do. I mean, even if they don't have a right to leave, but they leave, your money's not going to come in and you're going to go after chasing them. Wouldn't it be better now, if they're offering some kind of a buyout, to take that money and then lease the premises? Look, if they're leaving, they're probably not making enough money to make it worth staying. So if you get a judgment a year and a half down the line from them or against them, are you going to be able to collect? So it becomes a collection problem. Now, Victoria mentioned the personal guarantee situation. That may be helpful there, where the tenant leaves and doesn't have the right to terminate the lease. What we're recommending to landlords is to do some kind of give them a break on the, make half rent, for example, for 3 or 4 months, on the condition that if they stay that period of time, then when the business comes back up, then they try to reimburse the landlord over some period of time for the rent for the back period.
We have another question from Phil. It's, what about property taxes? All our hotels are currently closed.
I'm not sure what the question is. The owner has the, I understand. Okay, you're right. On triple net lease, typically the obligation, as far as the county is concerned, the obligation for payment of taxes is the owner's obligation. All right. So if I'm not paying the taxes to the landlord still has to pay those taxes, even if I have an obligation to pay them myself. That's a really good question, and that's a very common situation. I'd say that was a breach of the lease, and the ability, the right not to pay the taxes would follow whether or not you have the right to terminate the lease. So if you don't have the right to terminate the lease, you probably are going to be looking at possibility of the taxes as well. So when we settle cases for the tenant, we always settle it on an amount certain. Here, we're going to pay you X amount, and then anything else, CAM charges, taxes, whatever, is the landlord's responsibility. So to answer Phil's question, I think the tenant is still responsible for their payment of the taxes. We're talking about property taxes, unless the tenant has the right to terminate the lease because of the pandemic or for one or another reason.
Okay, we have another question. If the lease limits use, which is fitness use, and government limits capacity of fitness studios, making the business unprofitable, does that seem like a good defense to terminate the lease?
That's a good question. Most gyms are closed in this area. Not necessarily outside of the Bay Area, but I think it depends a little bit on how long the closure, the government closure restriction goes on. But at some point, if you're not making a profit and you can't admit customers because of the government restriction, you probably have a pretty good argument. But again, I wouldn't want you to, I'd still like to take a look at the lease, et cetera, et cetera. Does it limit it to this kind of business? Make sure that if it's limited to a gym operation, the leases and the restriction applies, you probably have a pretty good shot, at least after the first 3 months, to say, who knows when this is going to go on? I can't make enough money on the business. Be careful now, because a lot of companies, a lot of leases are written with the corporation as the tenant, but the individual owners of the corporation as the guarantors. So in those cases, even if the corporation goes into bankruptcy, they can go after guarantors. In other words, if the tenant corporation files bankruptcy, it doesn't preclude the landlord from pursuing the individual guarantors, or the guarantor might be another company. Does that help?
Yes, we are running close to the end of time, but there is a question that I'm going to try and combine so that we can have our last question. It's basically, they're asking, I think the bottom line is, if the landlord is telling them if they don't pay the full rent, they will issue a notice of lease default. And they're a new business and they've invested a lot in the space. And so they were trying to see, what are the repercussions that can happen there, or if you're aware of any bills that may be coming up that can support the tenants.
Well, yeah, I mean, commercial tenants have some protection. I haven't looked at the code for a while, but they couldn't proceed with unlawful detainers for 3 months. I'd have to take a look at that, but by and large, you have to take a look at the situation and see what are the unique factors in that might be helpful. I would have to check whether or not a landlord can proceed with an unlawful detainer right now in a commercial setting. I think they can. I'm practicing. Well, you know what? I just checked it the other day, and in Santa Clara County, I don't think you can proceed with a commercial unlawful detainer. I may be wrong about that. I'd like to check it. So that person wants to contact me. Actually, you can take a look at the site, the Santa Clara County site. It does have that information on it.
Well, thank you, Rich, so much. And so we have, I'm just going to put up your contact information here while you can do your final. Thank you, if you want to have any final words to say.
Yeah, my final words are, this is a horrible situation that none of us were even considered could ever possibly happen. It's very fluid, and I think you need to get some help from time to time. And I feel badly for places that are going out of business. The landscape is not going to be the same when it's all over. Businesses that were here before are going to be gone, and I just hope we can recover quickly. But in the meantime, we're going to have a lot of unhappiness, so to speak, and illness and death. On that happy note, thank you for letting me do this presentation. I think as long as I've given you the guidelines, you need to look at the document, you need to kind of get some opinion from somebody else. I think you're going to be doing the best you can for yourself. Thank you.
Well, thank you. Thank you everyone for being with us. And please visit our website to see other events, webinars that we will be doing in the near future. And have a wonderful afternoon.